Hi, I'm Roger Borden, author of the upcoming book on estate administration, covering topics such as wills, trusts, lasting powers of attorney, funeral plans, and everything associated with this industry. Today I want to talk about lasting powers of attorney and why they are as important as a will. What many people don't realise is that if they have a joint bank account and they don't have a lasting power of attorney, then there is a risk that they could lose their home. Every day we make decisions about our lives. The ability to make these decisions is called mental capacity. Contrary to popular belief, when we lose mental capacity, our spouse, our civil partner, or our children do not automatically have the legal power to act for us. In fact, no one has that power unless you have a registered lasting power of attorney. If you lose mental capacity, you're considered a vulnerable person, and the Court of Protection comes into effect immediately. The Court of Protection will contact all financial institutions to secure your bank accounts and freeze every account that's in your name, including those in joint names. So for couples where one party is the main breadwinner, or where a couple have a joint account from which all bills are paid, without a lasting power of attorney, these accounts are completely inaccessible. Just imagine what it would mean not being able to pay your bills from these accounts. After a couple of months, your mortgage will be seriously in arrears, your insurance policies cancelled. And if the insurance policies were there to pay off your mortgage or your potential inheritance tax liability, then you are financially in disarray. You can only write a lasting power of attorney while you have mental capacity. So if your accounts are locked and frozen, and your lasting power of attorney is your only way of releasing them, you really do have a problem. So how do you unlock these accounts? Well, you apply for what is known as a deputyship. That effectively gives you the right to look after the person who's lost mental capacity and unlock access to all their finances. The process of applying for a deputyship is both time-consuming, expensive, frustrating and controlling. It can take over 9 months to be approved, incur several thousands of pounds of costs initially, and then you'll be paying annual fees indefinitely. So what's involved in setting up a deputyship? Well, the chances are you'll need to provide a medical report on the vulnerable person. You'll be liable for court fees to agree the responsibilities you're permitted to use. There are fees involved in setting up a financial bond and annual supervision fees of several £100s. After all this, it will still be necessary to go cap in hand to the Court of Protection to be able to deal with anything outside the agreed areas of responsibility, and of course paying a fee each time to the Court of Protection for doing so. Of course you'll grieve when you lose the person you've been taking care of for all these years. However, you'll also breathe a sigh of relief when you're released from the shackles of the Court of Protection. There's absolutely no substitute for a lasting power of attorney if you need it. The only course open to you is to apply for a deputyship, which is expensive and time-consuming, as I've explained. So really, the only alternative is to consider writing your powers of attorney while you have the mental capacity to do so. My name is Roger Borden of City and Country Financial Services, and I can help you with wills, powers of attorney, trusts, funeral plans, and everything associated in this industry. I am a member of the Society of Will Writers, and I've written hundreds of wills since 2004. It's never too early to write your will, but it can be too late. You can contact me on 07958 221460, or if you prefer, you can email me on roger.borden@ccfs.london.